think all the front seats are taken.
They did not.
I appreciate that. See that because
I wasn't walking, but I was walking around. Yeah, like just to you want to breathe
Everybody look nice.
Is he?
1, 2, 3.
Once you hit like that, he'll.
It is live.
It
It is like that.
Okay. So we're all set.
Thank you.
We'll give everyone a little bit of time online to log in, and then we'll go ahead and get started.
Thank you, sirs.
Trying to adjust the temperature a little bit in the room.
We're bringing the heat.
Hi, everyone. Can you hear me okay? Yes. Yeah. Cool. Let me make sure my phone is on silent. And I encourage you to do the same thing. Just make sure your phones are on silent. And we're trying to bring down the AC a little bit. But welcome. My name is Diego Sanchez. I am the Director of Policy and Strategy for the President's Alliance on Higher Education and Immigration. And I'm really excited for us to have this event today. It's very, very important times. Very thankful to the Thurgood Marshall Institute at the Legal Defense Fund, to Dream.us, and also the Immigration Hub for partnering in this event. I'm really, really grateful for that. And also just want to welcome those folks in the live stream joining us. Good afternoon, and wherever you are in the country, welcome to today's conversation. So this panel today takes place at an important time as we commemorate the 70th anniversary of the landmark Supreme Court case, Brown versus Board of Education, during the week that we celebrate Dreamers, immigrant youth who came to the country as children. Our conversation today will focus on the fundamental role that the right of education has played across civil rights movements, starting with Mendez versus Westminster, which set the stage for Brown versus Board of Education, and later Plyler v. Doe. The panelists here will unpack the connections between Black and Latinx roles in civil rights litigation, and then delve into the impact of approaching immigration advocacy with a cross-cultural lens, elevating the importance of advocating for laws that ensure an accurate and inclusive education for all members of American society. And now I have the important and pleasure of introducing Carla, who will be our moderator for today's discussion. Carla McKenders is an expert civil rights, immigration, and race in the law. McKenders was recently appointed the new director of the Thurgood Marshall Institute, the multidisciplinary, congratulations. The Multidisciplinary Research and Advocacy Center within the NAACP Legal Defense and Education Fund that launched in 2015. Prior to the Institute, McKenders taught at Vanderbilt University Law School, where she directed the Immigration Practice Clinic and taught immigration, refugee law, and critical race theory. Prior to teaching, McKenders clerked for the Honorable Damon Keith with the United States Federal Court of Appeals for the Sixth Circuit, after earning her law degree at Duke University and her undergraduate degree at Spelman College. Thank you so much, Carla, for moderating this conversation for us, and I'll turn it to you.
Thank you, Diego. Thank you for joining us here today. I'm very excited for the conversation we have with our distinguished panelists. I will start by giving introductions of the panelists in the order from closest to me to the end. And to my left, we have Kevin Kinney. He is the Glucksman Professor of History at New York University, where he teaches and writes about U.S. immigration and global migration. His books include Making Sense of the Molly Maguires, American Irish: A History, Peaceable Kingdom Laws, and the book that we will be discussing today is Immigration in a Slaveholding Republic, Policing Mobility in the 19th Century U.S., which just came out last year officially. He is a distinguished lecturer at the Organization of American Historians, and he served as the president of the Immigration and Ethnic History Society from 2021 to 2024. Next to Professor Kinney, we have Victor Jones, my colleague at the NAACP Legal Defense Fund. He is senior counsel, where he litigates school desegregation cases and other education civil rights cases in federal courts. Through his efforts, he has helped thousands of school children in Louisiana, Mississippi, and Alabama obtain the equal education opportunities they are constitutionally entitled to, as recognized by the Supreme Court case Brown versus Board of Education. Victor received his BA in Literature from Xavier University in Louisiana. He has a master's in education from Harvard University and his law degree from Loyola University in New Orleans. Most importantly, before becoming a lawyer, he was a kindergarten teacher in a public school, and he is a native of Mississippi, and he is also a member of the 2022 class of Presidential Leader Scholars program. Next to Victor, we have Tom Sands, who's the president and general counsel of MALDEF. He leads the organization in pursuing litigation, policy advocacy, and community education to promote the civil rights of all Latinos living in the United States in the areas of education, employment, immigrants' rights, and voting rights. He rejoined MALDEF in August of 2009 after 4 years on Los Angeles Mayor's executive team. And then prior to that, he spent 12 years at MALDEF practicing civil rights law, including 4 years as a litigation director. He has served as lead counsel for numerous cases, including challenges to California's Proposition 187, California Proposition 227, and California's congressional redistricting. He has also argued before the Supreme Court in the United States v. Texas, representing the interveners defending the Obama administration's deferred action initiatives. And last but not least, my colleague, law professor, and now serves as an officer for the Civil Rights and Civil Liberties for the U.S. Department of Homeland Security. She was appointed by President Biden in 2023. Shobha Wadi, I forgot. I got so excited about saying she's my colleague. I forgot to say her name. Prior to joining the Biden-Harris administration, she was the Associate Dean for Diversity, Equity, and Inclusion, the Samuel Weiss Faculty Scholar and Clinical Professor of Law at Penn State Law in University Park, where she is currently on leave of absence. She is a scholar of immigration. She is an author of academic press books, case book on immigration and nationality law, and dozens of articles in various law reviews and law journals. And she previously served as the Deputy Director of Legal Affairs at the National Immigration Forum, and she was an associate with the immigration law firm Maggio Qatar in Washington, D.C. So I'm very excited to begin our panel today with the why. What brings you to the work that you're doing, and how did you get to the work? So if we can start at the end, Shobha, if you want to start us off.
Thank you so much. I'm really honored to be here with my fellow panelists, and really excited about this question too. The title of this panel is a full circle moment for me. I am the daughter of immigrants, and my parents grew up in India. They were married there, and after their marriage, they came to the United States. I was very fortunate to have a loving family and access to education. I first learned about the board decision as a middle school student, and it was really the case that sparked my own desire to be a civil rights lawyer, and also informed my journey later as an immigration attorney and as a scholar. I have also discovered that immigration is one of the greatest civil rights issues of our time. And during my career have really worked with and represented individuals and families who've gone through many types of journeys, many complex and arduous. So my identity and my values deeply inform my career. I began, as you said, as an immigration attorney before we had a DHS. Worked then in nonprofit, and about 16 years ago joined the faculty of Penn State Law, where I run an immigration clinic and teach courses in immigration, where I really saw firsthand the contributions and the presence of Dreamers and DACA recipients in my classroom and beyond. So I am honored to be in the position that I will talk about a little bit more during the discussion. Thank you for the question.
Tom, what is your why? What brought you into your work?
Well, I grew up in Los Angeles in an overwhelmingly Latino neighborhood. where we didn't necessarily see discrimination until you ventured outside of that community. But certainly I saw it and experienced it. I first became aware of the Brown case when I was an 8-year-old. Actually, as an 8-year-old, I had to go to school early because my mother was a classroom aide, and I had to sit in the back of the classroom where she worked, and I would go through the library. And this was the 1970s, because that's how old I am. And there was a book about African American history. There was no book about Latino history at the time in the early 70s. And I remember going through that book one morning and finding a discussion of Thurgood Marshall and the Brown decision, written for primary grade, so not terribly sophisticated. But it was an inspiration to eventually go to law school to become a civil rights lawyer, which is why I went to law school, to become a civil rights lawyer and hopefully to work for MALDEF. I did achieve my dream and have worked for MALDEF 27 out of my now 33-year career. And aging myself even more, I have to indicate that this is actually 40 years since I first studied Mendez versus Westminster and first wrote about it as a college student taking Chicano history as a sophomore. So 40 years of thinking about Mendez and Brown and working at MALDEF. Of course, Plyler, the organization's most famous case, has always been also of particular importance.
Thanks. And Victor, how did you go from kindergarten teacher to civil rights attorney?
Yeah, so like many people and like my colleagues have shared, my personal experience has very much defined the work that I do today. I grew up in South Mississippi. I grew up in poverty. I grew up in an environment where racial tensions were very high throughout my childhood. One of my earliest memories was visually seeing a Klansman in their costume and also remembering how normalized that was, and that I didn't necessarily have a visceral reaction to it, just to pinpoint how normalized it was. Also, the first time I was called the N-word was in kindergarten, and I still can tell you how I felt and how confusing that was, right? And I also attended a school district that struggled with meaningful integration. And so I knew in some capacity that I wanted to help children who looked like me and who came from the same experiences that I came from. I didn't know if that meant being a teacher or if that meant being a lawyer. And you know how when you're a kid, you want to be a policeman and a pilot and all of that. And so I felt like as an adult that I could do those things. And so I taught. I taught kindergarten for a couple of years in Somerville, Massachusetts. To this day, it was the most life-altering experience because I learned so much from my students. I taught 18 students, 11 different ethnicities. I mean, it was a snapshot of the world. They thought I was so dumb because I didn't know a second language. They would say, Mr. Jones, how do you know a second language? And I would always tell them, it's because I'm not as smart as you guys, right? But being in that space also allowed me to understand how marginalized groups encounter discrimination in similar yet different ways. And it also influenced my decision to want to impact systemic change for children on a much broader level. And so that's what brought me into the work of being an education civil rights lawyer.
Kevin, how did you get to immigration historian? What's your path?
Well, firstly, thank you, Carla and Gabby, and the panelists and the organizers for inviting me. So I'm an immigrant, and I'm a historian, and I'm a historian of immigration in the United States. So I write about some of the things I've experienced, and I write about things I haven't experienced that I know of from other immigrant groups. I come from a nation of emigrants rather than a nation of immigrants. I'm from Ireland. 10 million people left Ireland in the last 300 years. Only 8 million live there today, fewer than lived on the eve of the Great Famine. So emigration is the driver from that part of the world. I guess what I might have to offer today as a historian is, my sense is that we have a received narrative of immigration in the United States that has to do with uprooting and adjustment and social mobility and assimilation. And that story was written down actually by the children of immigrants who came in the Ellis Island period. It's a national myth, and there is some truth still in that myth. There are people from all over the world still want to come to the United States for that reason. But my sense as a historian is that national story, to the extent that it worked for the classic period of immigration, works differently in the century since the 1920s, when the immigration is predominantly Latinx and Asian, and increasingly from the Caribbean and West Africa. And the point we might develop today, it worked differently before that. It worked differently for a whole century before the classic Ellis Island period. So maybe there are certain contexts that are useful to us, especially in understanding the history of race in the United States. So that's where I come from.
Great, and we'll talk about your recent book during our panel. Tom, can you discuss the historical significance of Mendez versus Westminster and as a precursor to Brown versus Board of Education?
Well, as I mentioned, one historical importance is that I started reading it 40 years ago, and that was a long time ago. So Mendez case, that was a joke, folks, come on. So the Mendez case was decided in 1947 by the Ninth Circuit Court of Appeals. And it was a challenge, not the first challenge or the last challenge, but a challenge to segregation of Mexican-American and other Latino students in Orange County, California. It was a challenge that was based on the practices of more than one school district of assigning Latino students to their own schools, Mexican schools, that were uniformly more decrepit, less well kept up, and certainly with lesser qualified teachers, textbooks, and the like. The interesting thing is that even back then, the segregation was in part premised on a stereotype that all Mexican Americans are immigrants, because oftentimes school districts would justify the segregation on the basis of language. They would say they were assigning these students to that Mexican school because they did not speak English. Of course, it was really a racial assignment because they did not assess anyone's language ability. They simply looked at the students and said, oh, you go to the Mexican school based on their Latino appearance. But even then, tied to a stereotype that all Mexican Americans are immigrants, and tied to other very negative stereotypes about Mexicans being dirty and not sanitary and not knowing how to follow proper hygiene, and even worse stereotypes were used to justify the segregation. Now, in 1947, of course, the LDF was already engaged in its decades-long campaign leading up to Brown versus Board and the associated cases, challenging the doctrine of separate but equal in the South. But at the time, they were in the pursuit of that long-term strategy, and all of a sudden the Mendez case appeared. Now, it caught the attention of Thurgood Marshall and the LDF, and I believe it was Bob Carter who wrote an amicus brief on behalf of LDF that was filed in the Ninth Circuit in support of the plaintiffs who were challenging segregation. So it may occur to you, though, then, how come that didn't become the Brown versus Board of Education by going to the Supreme Court? And the reason is basically that the plaintiff attorneys in the Mendez case decided to agree with the districts that this was not segregation between two races, but segregation within the white race. In other words, the Mendez plaintiffs' attorneys decided to agree that Mexican Americans were white, a questionable proposition, not just sociologically, but based on other history at the time, but one that they convinced the school district to stipulate to. And as a result of that stipulation, they did get out of the precedent of separate but equal from the South by being able to say, no, that's a different kind of segregation. It's between races rather than within a race. And while it may still be the law that you can segregate on the basis between races in school, you can't do that within a single race. It also had the effect of effectively removing an existing California statute that, while peculiarly worded, seemed to permit the segregation in schools in California of Indians from Mexico. So they avoided both state law and the prevailing precedent of separate but equal by that stipulation. But the stipulation also had the effect of meaning that once the case was decided at the Ninth Circuit, it was not likely to be taken up by the Supreme Court because it simply didn't take on the doctrine of separate but equal, didn't threaten the doctrine of separate but equal particularly. So while the LDF took notice of the case and participated, as I indicated, it ended up being sort of a one-off without much attention until it got a postage stamp about 15 or 20 years ago. And at that time, it began to attract more attention. In fact, a little secret is that one of the major, and maybe the only book that is entirely about the Mendez case was written by a scholar who knew nothing about Mendez until she saw the postage stamp. So it's always given me a little bit of a letdown that the case got attention because a scholar happened to see a postage stamp. Otherwise, it never would have come to her attention. It, of course, comes to the attention of Chicano and other students well before that, including me 40 years ago.
Very interesting. I'd never heard the postage stamp. Victor, can you talk about, this year is the 70th anniversary of Brown versus Board of Education. Can you discuss the decisions and the historical significance of Brown?
Absolutely. So Brown v. Board was actually May 17th, 1954. So we just recently celebrated the 70th anniversary. As my colleague mentioned, Brown is the result of the consolidation of 5 cases from Delaware, Kansas, Washington, D.C., South Carolina, and Virginia. Now, Brown ultimately transformed society in 2 ways. The first is that it led to the dismantling of the separate but equal doctrine in all facets of American life, not just in education. And so it led to the desegregation efforts in military. It led to the desegregation efforts in housing. It led to legislation and litigation surrounding equal access to voting. It led to the formation of anti-discrimination statutes for individuals based on their disability status, based on religion, based on their sex. And so Brown transformed all facets of American life in that sense. Brown also, and I think we don't talk about this enough, but Brown also transformed society in the sense of it provided a new opportunity for aggrieved persons to seek redress through courts. Prior to Brown, if you had if you have incurred some type of injury, right, by the government, you could only litigate that case if the injury was physical or financial. Brown introduced this idea of stigmatic injury, emotional injury, non-economic injury, right? The premise that if you place Black children in inferior facilities, it stigmatizes them. That was the first time the Supreme Court recognized this idea of stigmatic injury. And so today, stigmatic injury is heavily relied upon by civil rights litigants as a basis for standing to be able to file lawsuits and to seek redress for discrimination. I think also Brown changed the way in which we use litigation as a tool for advocacy. Prior to Brown, someone would file a lawsuit for an individual purpose, right? Brown introduced this idea of impact litigation, meaning one person who is similarly situated from a group or a community or people throughout the country can use their experience, can use their lawsuit to transform the rights and access of opportunities for people who look like them. Brown also introduced the idea of what we call as litigators Rule 23B class actions, where you have a class representative who represents the interest of similarly situated people. And so all that to say, I think Brown transformed society in the sense that the way that equal opportunities manifested in different areas like housing and voting rights, that came from Brown. And it also transformed society in a manner in which people who are marginalized can seek redress for discrimination. Brown, too, I think changed society because it placed the role of social engineering in the district courts. Now, that was the first time, in America, we had seen this idea of a district court, a federal district court, being responsible for making sure that school districts implement their desegregation plans. In the case from Brown to not only place that supervisory jurisdiction over district courts to oversee this, it also required that the work of dismantling the dual system be done with deliberate speed. Now, here we are 70 years later, and there are a lot of school districts that are still under school desegregation orders. And so that idea or that promise to implement these plans with deliberate speed hasn't fully manifested. But there is one more case that I do want to talk about that I don't think gets enough attention in terms of how it transforms society, and that is Green versus the County School Board of Kent. It's from 1968, and here's why I say that. So the Supreme Court in the Green case defined what desegregation looked like. First, the Supreme Court stated that this work of desegregation that school districts needed to implement was a affirmative and continuing obligation. And so in all the other areas of integration or desegregation that I talked about, that language is there as well, right? So under the Voting Rights Act, there's an affirmative and continuing obligation for states to make sure that people have equal access to voting, right? Under Section 504 of the Rehabilitation Act, there's an affirmative and continuing obligation of schools to implement programs that don't discriminate against children on the basis of their disability, right? Under Title IX, similarly. And then also, Green was the case that recognized that the work of desegregation did not need to just happen on a shallow level, but by root and branch. And so what that meant is, in the context of schools, it wasn't just placing Black children in white schools and white children in Black schools. It was also making sure that Black children had equal access when it came to quality teachers. So that's faculty and staff assignment is what we call that. Equal access to academic programs within schools like AP, dual enrollment, career technical courses. Making sure that Black children or children of color are not disproportionately subjected to exclusionary discipline practices. Making sure that children of color and Black children have equal access to transportation opportunities, to extracurricular opportunities. And so that model of what it meant to fully integrate schools was used in other contexts, as I mentioned. So, for example, Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination, right? The manner in which employment discrimination is defined is based on Green. So it isn't just not hiring someone on the basis of their race, it's also not promoting them. It's also creating a hostile work environment. It's also transferring them, right? And so that model of eliminating, as we say, the vestiges of any form of segregation by root and branch doesn't just exist today in the school context, but in any civil rights legislation concerning correcting the past, the wrongs of the past.
Thank you, Victor. Let's move on to Plyler versus Doe. I'm going to ask this question for Shobha to give us the law professor kind of quick overview of Plyler versus Doe. And then, Tom, if you could talk about the significance of Plyler versus Doe, as this was a MALDEF case, and in terms of going from Mendez to Brown, and then rights for undocumented students in Plyler, and defending Plyler in light of our current landscape.
Thank you, Carla. So Plyler is a case that challenged a Texas statute that permitted local school districts to exclude or charge families and children who could not prove that they were legally admitted to the United States. And the court made two very significant holdings in that case. First, that these school children were persons under the Equal Protection Clause. And second, that the Texas statute violates the Equal Protection Clause. And so what was significant about the Plyler decision is that it, for the first time, recognized that all children have a right to enroll in K through 12 public education. And there are some very lasting influences of Plyler that also lead us to the landscape we're in today. They are the same children that surfaced as the Dreamers. And it is also a case, and lesser known, that a lot of the briefing that was tied to Plyler also talked about prosecutorial discretion and recognized that these are children who are, for the most part, going to be preserved through a tool of prosecutorial discretion that was on the books at that time. And as you all here know, it is a powerful tool today as we think about how the government prioritizes and usually based on an economic or resource dimension as well as a humanitarian one.
So I think it's important to note that when MALDEF began the Plyler case in the 1970s, it was by no means a foregone conclusion that the Supreme Court would end up where it did. In fact, it was viewed as a long shot. But folks realized something needed to be done because otherwise, even charging tuition would have the effect of excluding a huge class of students, those who are undocumented, from attending public school in Texas. And that would have really horrific dimensions of damage to the larger Latino community throughout Texas. So it was a long shot, but one that had to be taken. I think it's also important to note that although it was a 5-4 decision, and the fact that it's a 5-4 decision is why, ever since it was decided in 1982, there are folks on the hard right who have viewed it as vulnerable to challenge because it was at the time a close decision. It's important to note, however, that all 9 of the justices, even those in dissent, joined an opinion that said it's bad public policy. That is to say, all 4 of the dissenters joined a dissenting opinion that began by saying, if we were making a policy decision, we would reject this. It's terribly bad public policy. But the dissenters argued that was not their role. Their role was simply to decide if the Constitution prohibited Texas from doing what it did. So 9-0 on the policy question. And look, what we have today, we have folks who, as a policy matter, are somehow arguing that it makes sense to exclude kids from school. As I said, the right wing has targeted this from the very beginning, and there have been recurrent challenges. Perhaps the first was Proposition 187 in California in 1994, only a dozen years after Plyler, so close enough in time that the proponents believed that they could tee up a challenge and take it to the Supreme Court and get Plyler reversed. Of course, it didn't work even then, 12 years after the decision, because all of Proposition 187, basically all of it, was struck down on the basis of federal preemption, the supremacy of the federal government in regulating immigration. But something else happened during the pendency of the Proposition 187 case, and that is in 1996, the Congress enacted regulations through the Welfare Reform Act relating to immigrant eligibility for state-provided services. When it did that, it also incorporated Plyler directly into federal law. There is a provision of federal law that says, while we are regulating immigrant access, undocumented immigrants' access to other public services, we are not intending to disturb or change the decision in Plyler at all. That was what Congress said in 1996. And that's what folks today on the right don't understand. It's not as easy as teeing up a bad law, like the Texas law that was challenged in Plyler, and taking it to the Supreme Court and getting the new Supreme Court to revisit the reasoning of Plyler and reverse it. It's far harder than that, because it is now a part of federal statutory law. What that means is that preemption, the supremacy clause, indicates that federal government, because of its plenary authority over immigration regulation, has decided that Plyler is the law and states cannot deviate from Plyler. Now that it's in statutory law, it means you can't just go to the Supreme Court and re-argue the equal protection claims in Plyler. You first have to overcome very, very strong contention, one very, very strong even in front of a conservative Supreme Court, that in fact federal statutory law now preempts or overturns any authority of Texas or any other state to decide that they want to exclude undocumented students from school. And I'll end by simply saying we all know today that reversing Plyler would have devastating effects, and not just on the students excluded. Because what would have to happen is in many parts of this country a complete restructuring of public education. The removal of that many students from school would lead to shutdowns of schools, consolidations of schools, people having to change where they go to school, simply because the number of students would have fall so dramatically. At the same time, because state funding of schools is based on pupils in attendance, state funding of schools would fall dramatically as a result of excluding these students. In addition, of course, you would have a whole slew of students outside of school during the daytime, unprecedented in this country. So what would happen if we have a whole bunch of students out of school? You know what happens? They become a magnet for the kids who are enrolled in school to also leave school. Kids attract their peers. So we will see, if there were ever an overturning of Plyler, an actual implementation of the Texas plan for the 19th century, what we would see is a huge rise in truancy. That truancy might actually begin in individual families, because we know in many, many thousands and thousands of families across the country, there may be an older sibling who is undocumented, who would therefore be excluded from school, with a number of younger siblings who are citizens born in the United States who would still be eligible to go to school. So you know who are the first ones that will be attracted out of school? The younger siblings of that kid who is now prevented from attending school. What happens when so many kids are out of school? Well, we know that kids become victims of crimes. And that's what would happen across the country. It would have a devastating effect then on society writ large, not just the students being targeted, even though recognized by the Plyler majority as without blame and a protected class of sorts. The damage would not be inflicted solely on those students, but on all of society. Fortunately, as I said, statute now makes it even more difficult, a difficulty not recognized by the Heritage Foundation or any of the other far-right groups now advocating to overturn Plyler, but it is now doubly difficult for any state or locality to choose to ignore or defy the Plyler ruling.
Thank you. So we've talked about Mendez and Brown and the connection between the cases. I want to turn to Kevin to talk to us about immigration in the context of slavery. Most people don't connect the two. And in your book, The Problem of Immigration in a Slaveholding Republic, you made the argument that the existence, abolition, and legacies of slavery shaped the emergence of immigration policy at almost every stage along the way. Can you talk to us about how you made that connection and kind of the central argument in your book?
Yeah, I guess what I'm doing is just providing some context and background, which can be useful or can be peripheral. When we study history and we teach our students and we ask why you're studying history, the first answer we get is we're going to learn from the lessons of the past. And I don't know that we ever learn that much, or if we do learn lessons, I don't know that we apply them. But that can happen. We certainly can learn from the past. But we do discover where things came from. We discover legacies that I'll point to here today that are negative and some that are positive. And I think most powerfully, by just looking at a world that worked so differently, we begin to realize that 50 years from now, people are going to be writing the history of our world, and they're going to be saying, how could they? How could they have done it that way? How could they have believed those things? So there's power in that. I would say, so we think of the United States as a nation of immigrants. It was a nation of enslaved people. It was a nation of indigenous conquest at the same time. It is the country that has attracted more immigrants from more places than any other country ever in the history of the world. So immigration is an important part of the history. We think of immigration as a federal matter by definition. And so it comes as a surprise when you go to the Constitution and you discover that the Constitution is silent on immigration. Immigration in the sense of control over national borders, admission, exclusion, deportation. The Constitution does say something about naturalization of foreigners when they arrive, and it's a remarkably liberal, progressive policy, except that it's confined to free white people. Not until 1870 are people of African origin and descent permitted to naturalize, and really shockingly, the first time you hear it, not until the 1940s and 1950s can Asian immigrants naturalize as citizens. But beyond that question of naturalization, the Constitution is silent. And what that means is for the first century of the Republic, the states were controlling immigration and citizenship. The argument I'm making in my own work is that it's not until slavery is removed from the picture by Civil War and Reconstruction that a national immigration policy becomes possible. Because we have to think of this as the control of human mobility and migration in general. And if you look at what's happening for the first century in the United States, we think today, the situation today, it's almost the reverse. Today, it's much harder to move across international borders than it was in the 19th century because migration creates borders. It's not the other way around. You have to get migration and then you get restriction. So it was relatively easy compared to today to move across international borders, but it was much harder compared to today to move domestically. So if you were a poor person in the United States, you could be moved out of your community back where you came. The origins of that phrase, likely to become a public charge, lie in state level policies. If you were an Irish immigrant coming to the United States, the ship captain who carried you might be required to pay taxes or post a bond in case you became a public charge. If you were a free black person, there were severe restrictions on your ability to move within states or across states. And never mind if you were an enslaved black person. If you were a free black sailor visiting the South in the 19th century, you were imprisoned on your vessel or in jail for the duration of your stay because a free black person contradicted the logic, the racial logic of slavery. So that's the world we're entering into, and what's happening is that any time a state-level immigration law, and that would be in New York or Massachusetts, controlling the arrival of the poor, placing taxes or bonds on the arrival, say, of poor Irish paupers, anytime that comes before the Supreme Court, the court really backs away from the key issue. People in the South are looking very carefully at the idea that Congress might have control over one form of human mobility. If Congress could control the arrival of foreign paupers, well, what about the movement of free black people, or maybe even the interstate slave trade? So you have this constitutional battle between local sovereign police power, what's called police power, the power of the states to regulate their internal borders, and federal power over immigration, which might come under the Commerce Clause. And all of that is not really resolved or resolvable until the Civil War. But the related aspect, and the second thing briefly I want to say, the related aspect is citizenship. The Constitution mentions citizenship several times, but it never defines it. It acknowledges that there can be state citizenship and there could be national citizenship. And it says that there will be privileges and immunities attaching to citizenship, but it never says what they are or what this means until the 14th Amendment. The 14th Amendment defines national citizenship in the United States, and it uses only two criteria. You're born or you're naturalized. If you're born in the United States, you're naturalized, you are a U.S. citizen. I think that's important to our conversation today in two ways. That is a repudiation of the Dred Scott decision in 1857, which stated that no black person, free or slave, could be a citizen of the United States. And the Civil War is fought over that issue, and the 14th Amendment repudiates that form of racism. That, I think, is important because it's very hard to think of Civil War and Reconstruction as colorblind in a neutral sense. It's colorblind in the sense of outlawing discrimination based on race, but it is explicitly an attempt to redress Dred Scott. If you look at the Civil Rights Acts of Reconstruction, if you look at the Freedmen's Bureau Act, these are measures that are not simply neutral, they are ameliorative measures that are seeking to improve the condition of black people in the United States explicitly on the basis of slavery and racial discrimination. The second and final sense in which this is important is that the 14th Amendment defines citizenship, but it also extends the rights of due process and equal protection, federally protected against state action, to persons. And this has come up on the panel before, but if you want to know the origin of the equal protection for persons who are not necessarily citizens of the United States, it is in the language of the 14th Amendment. The final rub on this, of course, is that all forms of citizenship are exclusive as well as inclusive, and it does not, and it's relevant for today, extend citizenship to people who are not born in the United States and not naturalized.
Can you talk about, you've talked about the 14th Amendment, can you talk about the 13th Amendment and the connections you make between the 13th Amendment and the Chinese Exclusion Act?
Yeah, so what I argue in my work is that the Civil War and Reconstruction remove the political and constitutional obstacles to a national immigration policy. So for the first century of American history, there is no national immigration policy. It's all done by the states. So the different policies of the states constitute the immigration policy of the United States. Not until the 1870s does a national immigration policy emerge, and the argument I can make is that the secession of 11 states from the Union removes the political obstacle, and the abolition of slavery removes the constitutional obstacle. Because in 1875, the Supreme Court can say without any difficulty, unanimously, that immigration is a federal matter under the Commerce Power, a 9-0 decision. They tie themselves up in knots for a century before that. But here, again, there's a rub, because if slavery had been removed from the picture a generation or two earlier, if you could conceive of abolition actually happening in the 1830s, that does not mean that the federal government, specifically Congress, would have stepped in and regulated immigration in the sense of restricting the numbers. Because who were the immigrants? They were English, they were German, they were Irish. People didn't much like the Irish in the middle of the 19th century, but nobody was calling for numerical restriction of European immigrants until the very end of the 19th century. So there has to be something else going on, and that something is the arrival of Chinese laborers. So the arrival of tens of thousands of Chinese in the United States is the occasion for the intervention of the federal government to use its power to regulate immigration in the 1870s. There is, what Carla is alluding to here, a really pernicious argument. It's what I call a distorted anti-slavery argument. So under the 13th Amendment, slavery is abolished. There's always details in the language, except by way of punishment for a crime. That's familiar. But slavery is no more. The argument is made by opponents of Chinese immigrant laborers that they are coolies, that all Chinese laborers are coolies. That's the term that was used, that coolies are slaves. Both of those propositions are false, but the third part of that argument is coolies are slaves. You cannot have slavery in the United States, and on anti-slavery grounds, an argument is made for the exclusion of the Chinese.
Thank you for that history lesson. It's very important that we begin to make these connections. Shob, I want to talk to you about your work on prosecutorial discretion and the Chinese Exclusion Act, kind of continuing the conversation. Can you talk about your work in the area of prosecutorial discretion, kind of beginning with the Chinese Exclusion Act?
Sure, thank you. And it's a late discovery, really. A lot of my early work on prosecutorial discretion and deferred action, chronicles using data sets obtained largely through FOIA or the Freedom of Information Act to really help identify a through line on what are the types of cases that have from the 1900s early on to the present informed who is a lower priority or protected through a type of prosecutorial discretion such as deferred action. But you set me up well right after the history lesson to really talk about a more recent project that I looked at, and that was a tool of prosecutorial discretion during the Chinese exclusion era. One of the laws during that era was called the Geary Act of 1892. It extended the Chinese Exclusion Act to Chinese laborers who were living in the United States if they were unable to produce certificates akin to today's green card to show that they were lawfully residing, they were subject to deportation and severe criminal penalties. So the Geary Act was challenged. It was in a case that went all the way up to the Supreme Court in a case called Fang Yu Ting. What is an interesting story behind the case is that the Chinese community was very organized. And by the time the case came to the Supreme Court, only a fraction of Chinese had in fact registered. And it was in many ways an act of civil disobedience. They did not agree with the law. And even though the case was not favorable towards those challenging the law, most were never deported. And that is what I call the greatest untold story of prosecutorial discretion. And there are archival documents and historians that I spoke to really think about, how many funds were left or available at the Treasury. So resources certainly had something to do with it. There were geopolitical influences. And of course, there was a humanitarian dimension of sort. So at the end, I also trace it to the modern era. It's a pretty non-linear thread, but what does it mean to have a prosecutorial discretion guideline from 2000 that names community attention, for example, as a factor to consider in making a prosecutorial discretion decision? How does it tie to the current policy under the Mayorkas memo on prosecutorial discretion that says participation in First Amendment activity should not be a basis for immigration enforcement? So these are some of the things that I explore in that project.
Thank you. So as we're talking about these historical intersections, Tom and Victor, can you bring it to present day in terms of what are some of the key similarities and differences between the civil rights movement in the area of education equity that are led by the Black and Latinx communities?
Well, I certainly think that as Mendez preceded Brown, Brown itself then catalyzed much activity in the Latino community around equity in education. So you see in the late 1960s the blowouts in Los Angeles and other movements by Chicano students across the country demanding that their education be made equitable. So I do think there have been reinforcing effects across both communities' work in the area for decades and decades, and I think it continues today. I certainly, several years ago, would identify in every public speech the Dreamers as the most powerful youth activist movement in the country since the 1960s. That's then followed by the Black Lives Matter movement, in many regards led by youth. So I think, again, we see this mutual reinforcement aspect that occurs. I think it's important to note that at a certain point, the two communities were forced. I don't mean forced, they would have done it in any event, but required to come together because of what came to be called Texas-style integration in the aftermath of Brown. Why it was called Texas-style integration is that's the state that had substantial Black and Latino populations, and the state's districts first attempted to integrate to comply with Brown by mixing Black and Latino students alone, leaving the white students all by themselves in still segregated all-white schools, and that was called Texas-style integration, where you simply integrated the two communities of color and left whites out of the picture. Obviously not acceptable, ultimately rejected by the Supreme Court in a case out of Colorado, but really an important occurrence that meant these two movements had to come together to ensure they weren't played off against one another. Fast forward to today, and I already mentioned that I believe that up to Black Lives Matter, the Dreamers was the most powerful youth activism since the 1960s. And that was really a manifestation of a demand for true education equity, because it wasn't really just about having the right to stay. That probably would have occurred for the vast majority of people anyway. It really is about having the authority to work. So if you're going to get an education, most folks get an education with an eye to a profession, to being able to work, to be able to really take your education and put it to work in your own profession. So having work authorization is essential to being able to do that. So the through line from Plyler then to the proposed DREAM Act and DACA is quite clear as a movement of education equity. If you're going to give us access to K through 12, what follows from that is getting access to college education. What follows from that is getting access to graduate education. What follows from all of that is the right to work in your profession and to pursue it throughout your life. And that's ultimately what DREAM Act and DACA was about.
Yep, I would just add that in my experience, the movements are entirely more of the same than to the extent there are any differences. I think we're talking about, for both groups, equal access to educational opportunities. And the reason why the focus is on equal access is because, data from longitudinal studies show that Black and Latinx communities are the groups that are more likely to be subjected to some form of denial of educational opportunities. Any school to prison pipeline study you look at, the number one group is Black students, secondarily Latinx students, right? When it comes to access to academic programs, the same. Even in studies where where researchers are viewing the populations of students who are on IEPs or receiving special education, we see racial disparities in access to special education programs persistent among the Black community and the Latinx community. And so I don't see in practice there being much of a difference. I think to the extent there are any differences, it's more so shaped by geographic or local or socioeconomic factors.
Thanks. Shobha, can you talk to us about the integration of cross-cultural perspectives when we're talking about education equity and immigration advocacy efforts?
So as I think about the cross-cultural perspective in the seat I hold now, what I can share and to reframe a bit is just how crucial it is as a federal agency, both internally and externally. The Biden-Harris administration has been committed to having a workforce that looks like America. And so that cross-cultural perspective inside DHS, the third largest federal agency, 268,000 employees, is ever important. The external piece is also important because we interact with millions of customers every day, maybe more humans than any other federal agency, many of whom speak a language other than English, or for whom English is not their best or first language. And so two areas that we've really focused on to really illuminate our cross-cultural perspective is embedding language access in all of the department's programs and activities, and more recently putting out the department's first ever Indigenous Languages Plan to really look at the unique needs of Indigenous language speakers, women and children, and their unique needs, as well as reducing some of the barriers that exist to finding qualified interpreters who speak Indigenous languages. So I think it is built into the fabric of our work and the work we have to continue to do internally and externally as an agency.
Thank you. Victor, can you talk to us about what steps need to be taken to ensure equitable access to education for immigrant students, Black students, students of color, and some of the work that you're currently doing to ensure equal access to education?
Yeah, I think one of the things that we advocate for is the idea that equal access to education is something that needs to be strengthened through federal legislation. We have seen time and time again that states, if left to their own devices, will not fulfill that mandate. And so I think, when we're talking about what are some next steps or what are some goals that we should aim for, we have to be able to, as advocates, identify ways to push back on this idea of anti-federalism, of this idea of hyper-localism, right? I think just from a policy standpoint and even from a litigation standpoint, that is the way that we can ensure that equal access is obtained in communities of color.
And Tom, can you talk to us about how immigration has historically impacted the landscape of education equity in the U.S. And what parallels we can draw for immigrant youth today?
Yeah, I think that Plyler was an important step, but still an incomplete step in a number of ways. There remain aspects of education that have been closed off to folks because of immigration status. If, for example, you're talking about a paid internship, that's not available to someone who does not have work authorization. If you're talking about certain field trips, even a trip to a local federal facility at times has not been available to folks who don't have a federal identification form or access to one. Even in border communities, northern border, southern border, field trips that cross the border are obviously not available to someone who is undocumented and unable to leave the country and re-enter. So there are innumerable ways that what Victor talked about, root and branch, continues to be a problem where there is basic access, but you need to make that access more complete and full. In some ways, that parallels the experience for students of color across the board, regardless of immigration status. We continue to see inadequate, inequitable access to some of the most important adjuncts to education that you can imagine, whether that is who gets access to the internship, who gets access to the civic engagement opportunity, who gets access even within a school, an integrated school, who gets access to the AP classes, who get access to the IB classes, who gets access to the honors courses. But we know that those are still heavily influenced. Who gets onto the academic decathlon team, a team that is supposed to reflect A grade, B grade, and C grade students, but almost always excludes Black and brown students regardless of the situation. And these, not coincidentally, are the kinds of extracurricular or adjuncts to the strict curriculum that often influence access to higher education, particularly important after the decision a year ago in the Harvard and UNC cases. So I think the issue of full integration of immigrant students into education, full equitable integration into all aspects, parallels the continuing challenges of Black and brown communities writ large, where integration in a school itself does not come close to guaranteeing integration in each classroom, particularly the high access classrooms, or to some of the outside the classroom activities that bear a significant impact on success ultimately in education.
Thank you. Shoba, can you talk to us about the role of the Department of Homeland Security specifically in balancing civil rights and national security when we're trying to provide inclusive education opportunities for immigrant communities?
So I might reframe
It's
that
okay.
question too, in that, you know, for the department, the work of the Office for Civil Rights and Civil Liberties is really, rather than a balance to national security, embedded and integrated into everything that we do. So I can provide a few examples. They go beyond education, really, but in the area of artificial intelligence, our office is involved in every step of the AI process, identifying risks, mitigation, providing oversight, chairing responsible use for the department, reviewing every facial recognition and facial capture use case, and identifying and ensuring that there is no unintended bias in any tool being used by the department. Similarly, since we were talking about some later civil rights statutes, our office also oversees enforcement with Title VI of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, and national origin for organizations that receive DHS federal assistance. And so that's now also been interpreted to include shared ancestry and ethnic characteristics. So this could include colleges and universities who are DHS grant recipients. And maybe as a final example, one of our earliest statutes our office was created with the department is our statutory investigative authority. We investigate allegations of civil rights and civil liberties abuses that may include detentions of conditions, allegations, use of force, or racial and religious profiling. So a little bit beyond education, but really to show that it is not a balance or an either or, but rather to promote civil rights as a way to advance national security.
Thanks. Kevin, I want to transition it back to you and talk more about the racial dynamics in immigration. And at the end of the book, you come back or discuss the Supreme Court case, Arizona versus the United States, and you talk about, you compare it with the antebellum period. So can you talk about what argument you make in terms of how Scalia's opinion in that decision is similar to some of the arguments that were made during the antebellum period?
Yeah, so this is all about the idea of immigration federalism, which is alive and well today, just as it was in the 19th century, in a different form. And again, I'm afraid as a historian, to answer that question, I'm going to have to go back to 1875, way back to ancient times. And, so I mentioned that by 1875, the Supreme Court is unequivocal that control over immigration in the sense of admissions, exclusions, is a federal matter, something it could never decide in the era of slavery. By 1875, that's clear cut. The argument is principally on Commerce Clause grounds, that Congress has power under the Commerce Clause to regulate commerce between nations, and immigration falls under that heading. But the court also introduces a secondary consideration, which is that if a state makes its own immigration policy, that could embroil the United States in a foreign conflict. and any retribution would come against the United States, not the individual state. That's in the case of Chilong versus Freeman. So just to complete the story, the Commerce Clause in the end isn't sufficient as a grounding for authority over immigration for the courts. In 1889, in the Chinese exclusion case, the Supreme Court rules that authority over immigration in the sense of admissions and exclusions is inherent in the sovereignty of any independent nation. So along with the plenary power doctrine, which is the allocation of that power to the political branches of government, is the claim that authority per se is just inherent in the power of the nation. So that has really gone uncontested until recently. It's being contested now in Texas and in Arizona and in Iowa in certain ways, the extent to which individual states can, in effect, make foreign policy by controlling aspects of immigration that over the last century and more were firmly delegated to the federal government. So I think we have to think of immigration law in two senses. One is the control of national borders, and the other is once foreigners have been admitted to the United States, the old traditions of local police power are still very strong. States exercise their power and authority to regulate the lives of immigrants, often to monitor and punish them, as we see in Texas and Arizona, sometimes to assist and integrate them, as we see in sanctuary movements and other locally based social and political movements in different states, right? So there's a bifurcation in immigration federalism. So in the last, the Arizona SB 1070, that was the case came before the Supreme Court in 2010, and the court curtailed the ability of Arizona to control immigration to the extent that it was infringing on federal power. Because really the purpose of that statute was not simply to monitor and surveil immigrants after they had arrived, it was explicitly to deter immigrants from coming. And I think something similar earlier in Proposition 187, there's an equal protection argument, but there's also a preemption argument that the state is intruding on federal power. So Justice Scalia celebrates the old state police powers that I mentioned at the beginning of the conversation, the ability in the antebellum period of local and state jurisdictions to move the poor out of their jurisdiction to where they came, or to control the movement of free black people within or across borders. And Justice Scalia says that the state of Arizona would not be a sovereign state if it did not retain the power to do that. And all the more so, in doing it, it is supporting federal immigration policy, not resisting it. So that's Scalia's position. He's in the minority. It's 6-3, I believe, or 7-2, and most of that law is curtailed. So I think what's happening here, if we think of it in the longue durée of immigration federalism, there's still a contest between national and local, and I couldn't agree more with Victor on the need for federalism to trump, if I could say, localism in most cases. But there is the possibility that local sovereignty can be used for sanctuary and for other purposes. And there is an analogy, I'll end again with the historian's analogy. In the 1840s, there was a case came before the Supreme Court, Prigg versus Pennsylvania, and the court invalidated what was called a personal liberty law. That was a law passed by a state to protect free black people who had moved into the state from being returned into slavery. And the court said, no, the federal law has supremacy here under the Fugitive Slave Act. But the court also said that although the federal law takes supremacy over the state law, the state does not have to enforce the federal law. It's a federal matter in that sense also, that the government has to enforce it. And of course, slave owners look for a stronger Fugitive Slave Act and get one in 1850. Northern states passed personal liberty laws saying we're not going to enforce federal law. Now, the states can't violate federal law, but that doesn't mean that they have to act as agents of law enforcement at the federal level. And I think a similar argument can be made on the extent to which a local jurisdiction will choose to be an agent of ICE or to keep its distance from federal authorities. So again, that tension in immigration federalism is there. Scalia came down very firmly on one side, and citing a legal scholar, Gerald Newman, who, in ways that I doubt Professor Newman was too thrilled by, because Professor Newman had written about what he called the myth of open borders. Borders in the 19th century weren't closed, international borders, the way they are today. They're not normatively closed, but that didn't mean they were wide open either. There were all sorts of restrictions on the movement of people internally.
Thank you. As we begin to move towards,
Can I just
okay.
make one comment about Arizona, two comments. One, it's a little ironic that Scalia is making these arguments about Arizona because Arizona didn't become a state until the 20th century, like 40 years after that 9-0 decision in 1875, making it clear that states don't retain the sovereignty to regulate immigration. But of course, that didn't bother Scalia in making that argument. But the other thing to say is that Arizona is not quite in the mix on this issue yet because their measure is on the ballot. And that gives me the chance to say, if you're in Arizona, make sure you vote on that ballot measure. If it stays on the ballot, certainly it's being challenged whether it should stay on the ballot. The states that are already in this battle are Texas, Oklahoma, and Iowa. But Arizona depends on a popular vote because the right-wing legislature can't legislate by itself, so it can, by itself, put something on the ballot, and folks should look forward to that in November.
Thank you for that. As we begin to wrap up, I have a question for all of our panelists. What do you see as the biggest challenges and opportunities in the fight for inclusive education, Victor, education and immigrants' rights, Tom, and for Shobha, what role does the Department of Homeland Security Civil Rights play in addressing some of these future challenges and opportunities? So we'll start with Kevin as a historian, and then we'll work our way down the table.
I'll pass it along.
Okay.
Sorry.
So I think the biggest challenge, one of the biggest challenges, is this erasure of truthful and accurate history. Even Thomas Jefferson himself said that education, public education, is the cornerstone of democracy. And so having a generation of ill-informed or under-informed people is a threat to democratic institutions. And there's really no other way to put that. I think another big battle would be the resistance to efforts to undermine or pushing back on the efforts to undermine Brown and its promise of equal educational opportunities. Of course, equal educational opportunities influence social mobility as well as quality of life, but also access to equal educational opportunities is a good thing for all children of all backgrounds. It's very important. I think about anecdotally my experience as a kindergarten teacher teaching children from 11 different ethnicities and countries and backgrounds, and how that experience really taught me to understand people who don't come from the same world as me, right? And to be able to have had that experience as a 5-year-old, I think would have been even more magical. And so I always hold schools as sanctuaries or as microcosms of the world, as I say. And so if if society is in the direction of segregating children, again, which 75% of Black and Latinx students today attend highly segregated schools, then I worry that fundamental, basic social and emotional intelligence to be able to coexist with people from different backgrounds is undermined. And I think the last point, I'll literally just say equitable funding, and we know where that's going.
So I, for one, think that the historical lesson is very important, but I'm not concerned that we're going to go backwards in the way that Scalia might have liked on the issue of who controls immigration in this country. And it is my hope that we take some of that nationalization and move it to the education arena, where we even today have too strong of a national devotion to local control when it comes to education. And local control remains a major, major obstacle, in my view, to full equity and civil rights in the education arena. We need the federal government to be more aggressive than it has been. It has been only marginally prescriptive when it comes to receiving funds under the Elementary and Secondary Education Act. We need the federal government to be much more aggressive legislatively about introducing some national principles, some national obligations when it comes to education. But what gives me hope is youth. I remain convinced that youth have a better understanding that all of these endeavors are not individual competitive endeavors, that public education has the label public on it, not just because the public pays for it, but because the public in its entirety benefits from it. And we should not go further down this road of individualistic, competitive thinking when it comes to education. I think youth are further away from that. They see this as more of a collective endeavor across the board, and that gives me some hope for tackling these issues.
And I think for the Department of Homeland Security, there is always the opportunity to collaborate. At the Office for Civil Rights and Civil Liberties, we will continue to advance civil rights through policy advice, investigate complaints, lead our EEO work, as well as implement the President's equity-related EOs for the department, to name a few. From where I sit, the biggest challenge starts with the limitations of executive branch agencies and the work we do. Because ultimately, if we are going to have a policy solution, it will very much require an act of Congress. So there's a lot of good work that is being done by federal agencies across the executive branch, but when it comes to real reform and solutions, in particular around immigration, we need Congress to act.
Just to briefly add, actually, I'm reminded of Carla's own work on the category of tiered personhood, where she's comparing the pernicious effects of Jim Crow with the treatment of undocumented immigrants today. And the word that came through most strongly for me when I was reading about these legal cases, preparing for this, is the creation of an underclass. Don't create an underclass, and I think that echo Tom's faith in the current generation is not thinking that way.
Thank you. It was amazing to be able to bring you all here together and to have a historical perspective on education equity and connecting Mendez and Brown. So thank you so much. If you would join me in thanking our panelists.
Thank you, Carla, and thank you all for sharing your expertise and your insights with us. I'm excited to introduce our next speaker. Her name is Lisa Women Cho. She's a Dream.us alumna, a first-generation law graduate from the City University of New York School of Law. She earned her BA in criminology, graduating magna cum laude, no big deal, from the John Jay College of Criminal Justice at CUNY. And I'll skip this part and let her share the good news. And now you have to. As a staff attorney at the New York Legal Assistance Group, she provides free immigration services, offering compassionate advocacy to clients navigating complex immigration cases. And now I'll turn it to you so you can share the goodness. Lisa.
Thank you, Diego, for the introduction. The good news he did not want to share and gave me the opportunity to share was that I recently passed the February bar. And So I've joined the list of amazing attorneys sitting here as well as the amazing historian here. So thank you for inviting me to share my experience as an undocumented DACA student. This feels very surreal to me because I've learned about Brown v. Board of Education throughout my education, as well as Plyler v. Doe as a 1L. Sorry, Tom, I'm going to make you feel so old. And now I'm talking about the impacts that it has on me, as well as the immigrant community. I am a product of the very public education system that was built through Mendez, Brown, Plyler, and then for law school, Swelt v. Painter. My journey through public education system is not without its ups and downs, because we cannot have equal opportunity in education when we do not address the compound issues that immigrant students face in their lives outside of getting an education. My biggest struggle was funding my education. I'm the youngest of 3, which means I got to see the financial toll that my parents went through to pay for my siblings' education out of pocket. But regardless of how expensive college tuition was, my parents would work 6 to 7 days a week for 12 plus hours to pay for my siblings' education. I saw the fatigue on their faces and body every day, coming home to only have a little time to relax before falling asleep because of how exhausted they were. I didn't know if I could put my parents through paying for my education out of pocket again. I thought about not going to college after attending, I went to law school afterwards. So after attending a workshop with the college office at my school, where the college advisor, a really great person, but was ill-equipped in giving financial advice for undocumented students. And the panel was actually lumped in with international students, which that is a whole issue of itself. We were told that our options were to look for scholarships or join the military. For those of you who don't know, there was a program that allowed for certain non-citizens to join the military and eventually get citizenship. This program is now indefinitely paused as of 2016, and I didn't want to join the military. This advice was not helpful, especially if DACA students did not want to do it, and it was limited to only those who had DACA. It was quite defeating to hear those words. Those were my options. It meant that I had to work 10 times harder than other students to even go to college, which, again, that is in and of itself a barrier. I had to look for scholarships myself to pay for college tuition. Some of you may think, why not apply for FAFSA, the federal aid for students? Undocumented immigrants do not qualify for FAFSA. It's actually on their website that even with DACA, you are not eligible for FAFSA. Private loans are another option, but they require citizen co-signers. And I was uncomfortable with taking out a private loan or even asking someone to take on a loan with me. But through word of mouth, I heard about the Dream.US scholarship through another scholar. I was shocked that there was a scholarship specifically for immigrant students to achieve higher education. I applied, and April 18th of 2016, I got accepted. I looked through my email for this. I don't have a photographic memory, for those wondering. It was enough to pay for my undergraduate education. I did not have to burden my parents with paying for my college tuition, and I know they would have gladly done it. Funding my education not only allowed me to attend college on a full ride, but also allowed my family to save up money to eventually purchase a home and eventually save up to pay out of pocket for my law school education. And I am proud to say that I am debt-free, for those of you wondering. I eventually graduated during the pandemic. I know, very sad times, and went to law school during the pandemic. Applying to law school and finding fundings for the tuition was the same song and dance. I knew I needed to buff up my resume and stand out. I knew that I did not qualify for FAFSA, and having to sit through 2 mandatory financial aid workshops through my pre-law pipeline program, I was painfully aware that I did not qualify. I was used to fighting for my keeps and earning my every degree, achievement, and position with little to no resources. My education shows that there's a lot more we need to do to support Black, brown, and undocumented students. Mendez, Brown, and Plyler are just the beginning, not the end. We need to keep fighting to give every student an equitable opportunity to earn their degrees. And it starts with changing the requirements, giving us a chance to show you how amazing and brilliant we can be when given the resources to meet us where we are at. Provide us with the financial aid and advisors who know how to assist us. We've accomplished a lot just with DACA, but imagine the amazing things we can continue to accomplish if given the chance to go to college, grad school, and excel in our career. Before I end, I wanted to give a huge shout out to all the community organizers, leaders, and advocates who are here this week and everywhere else fighting for our cause. Keep it up because we are the ones keeping this conversation alive. No matter how small the issue or when people look down on our advocacy, do not be silenced or think our cause is lesser than others. And now to close out, I would like to call up the president and CEO of the Dream.us, one of the fierce advocate in immigration and an amazing mentor, Gabby Pacheco.
I am so proud of you, Lisa. Thank you so much for, I know you have so much going on in your life right now, including some cases. As an attorney, now she's working on cases, and it's just so amazing to hear that. But I wanted to say that this is a long time coming panel. And this wouldn't have been possible if it wasn't for Carla, which I just met a couple of months ago. And as soon as I sat in a panel with her, I told her, girl, we're gonna do amazing things together. So I just wanted to say thank you. This wouldn't have been made possible if it wasn't for you, for your team, and all the work that you're doing. And I also wanted to, thank the panelists that when we call or send emails, you say, yes, we will be there. This is very critical. And a lot of the times when we talk about the issue of immigration, the issue of immigration is only looked at a lens through the law, through did you do this the right thing or the wrong thing? But we failed to look at this as a civil rights issue. And so, as Shobha, as you mentioned, this is the civil rights issue of our time. And I wanted to first say thank you to all of those that are here in the audience. Thank you so much for making your way here. We have a lot of different events that together we are doing to celebrate not just what has happened with the DACA program, but the individuals who have been able to excel. We want to be able to tell the stories. To those who are watching, thank you so much for being with us today. And if you feel comfortable, I wanted to ask the individuals who are in this room who are dreamers to please stand because this is for you. Thank you. So the Legal Defense Fund has had a celebration that it's been, what is the title? The 70th anniversary. We Are All Brown. And I feel, that is such a beautiful reminder, right, of the fact that we are all brown. And that the trajectory of the fight that we have had, even though it's been long, even though we've been able to win in many cases, we are still fighting. And so today, half of the country provide in-state tuition for Dreamers. 18 of them provide state aid, but the other half has no policy whatsoever. As a matter of fact, there are 3 states, one, like the state of Georgia, that bans undocumented students from being able to go to their higher education state schools. Segregation is still happening in this country, and it's unacceptable. So today we want to make sure that we bridge the gap, that we remind our elected officials, that we remind the leaders, that we remind the individuals and the people that have a power to do something, and that every single one of us that has a voice uses it. Because those individuals that you just saw stand up need us. And those that don't have DACA, which today, majority of the Dream.us scholars are fully undocumented. And so we're talking about generation of young people who have so much desire and talent and potential, and yet we are creating an underclass of them. So we want to end today by saying thank you, by asking you to please follow. And I have 5 things that we must do. We must first ask ourselves what kind of nation we want to be. If we want to be a nation that continues to move forward, that wants to empower our community, every single member of our community, then we must, 2, demand that our elected officials pass bipartisan legislation that solves this issue and that realizes that immigration is something that has been happening since there was human beings on earth. 3, we must ask the administration to go above and beyond DACA. There are certain things that they can do to ensure that Dreamers are able to facilitate their advanced parole, get D3 waivers, to be able to do things like H-1Bs, to be able to leave this status that is not permanent. 4, we must support the brilliant minds, the young people, by either ensuring that there are scholarships, that there is opportunity for mentorship, internships, fellowships for them. Businesses, we have to ask ourselves, what are we doing to ensure that we are including and not excluding this community of people? And the last thing we must do is show up. So thank you for showing up. We did it backwards. You're doing number 5 already, and you're doing it well. And I just want to say it's graduation season. On Friday, we were celebrating our very own Chief Operating Officer, now Dr. Hain Lee. And I feel that after today's session, we should all get some sort of degree, because I feel a lot smarter today after hearing them. So please, once again, let's give all of them a round of applause, to them and to Lisa. Thank you. Thank you for coming.